Okay, good evening, everyone. Like Antoine already mentioned, I'm Driek Deferme, one of his colleagues, meaning I'm a PhD student at the KU Leuven. And the presentation of today is indeed about time limitations and criminal law. My main PhD research is about time limitations, but then in civil law. But I already, had some kind of discussions and also wrote a paper about time limitations in criminal law. Now, okay, so the slides are moving, I guess. Can someone not? Yeah, okay, very well. You see the table of contents. It seems like a lot. It really is not. And for the first point of the presentation, just a very quick focus to have non-misunderstanding about which direction this is all going into. So first, I'm going to quickly explain what are time limitations and how do they function and why do we have them in criminal law from a traditional point of view. And then I go into all the criticism and modern developments on why they're kind of deteriorating, why they're they're diminishing in their importance. And I do this from a kind of a legal perspective and also from Belgium law. Now, I will make some comparisons to other countries, and that's more to like broaden the view, to have other arguments, other viewpoints, so you can make up your own mind about the Belgium system. Now, with the legal focus, I mean I will also give some other arguments that are political or sociological, but because it's not my main expertise or my main domain, most of the time I will not go in depth into them. Now, other disclaimers are the legal presentation now misses some nuance. There are some very complicated technical rules where, yeah, the basic rules sometimes kind of function in different ways. Excuse me if I'm not fully correct on that part. And also, excuse my English. I'm not a native English speaker. I'll do my best, but my pronunciation on some words can use some fine tuning. And also, I'm kind of known for my chaotic presentation style. So if I jump from one slide to another or refer to two slides back, please accept it. It's kind of how I normally present everything. Now, general legal background. First of all, kind of terminology. I'm going to mention a lot of times the public prosecutor or the public ministry. Now, most of the people know them as attorney generals from kind of the common law movies like in the US and so on. Now, in civil law, most of the time we just talk about the public prosecutor or the prosecutor in short. Now, what does he or she? She kind of represents society in everything that has to do with crime. Why? Because the state has a monopoly on violence. You as an individual can't enforce anything. So the state does it for us, and it's the public prosecutor, yeah, that kind of represents us in the society. So when I talk about the public prosecutor, you know, it's like the state society that I'm talking about. And then a quick difference, I'm going to use the terms suspect or accused or wrongdoer interchangeably during the presentation. And that means a person where an investigation against has started, but has not been found guilty by a judge. That's the difference with someone who's guilty. There, the judge has already rendered a verdict and said, okay, you committed this crime. Whereas a suspect or accused, it's still kind of in the dark. Did he do it? Did he not? Um, but it's a very important difference to make. And then some quick principles of criminal law who are not lawyers. Well, you have the presumption of innocence, meaning that nobody is found guilty, like I mentioned, until it is proven beyond a reasonable doubt that that person committed the crime. Meaning a lot of evidence is needed, and it's the judge who decides, okay, we can now accept that that person has been proven beyond reasonable doubt. Now, why that presumption? It is to avoid false positives, meaning we do not want innocent people be thrown in jail. Yeah. So we rather as a society choose that innocent people are not thrown into jail than guilty people who go free. Yeah. So it's kind of a balance that we as a society make and that we agreed upon as a basic principle. Now then, finally, Driek, we come after 5 minutes to what are time limitations? Well, Those are abstract terms set by the legislator where it is no longer possible to go to trial. Meaning, for example, when someone steals a wallet from you on the street, the public prosecutor has 5 years in Belgium law to bring a court case against the wrongdoer. After 5 years, the legislator states, okay, we're just not going to have any trial at all, and meaning it's kind of a procedural bar. Meaning, again, the wrongdoer is not acquitted or not found guilty. It just stated, okay, enough time has passed, the claim is inadmissible. So we'll never know if the wrongdoer was guilty or not. It's very important. Also later on, you're going to see why. Now, time limitations have a lot of technical rules, but that's not the focus today. I'm going more into the reasons why and the political backgrounds. Now, when we look at the reasons for time limitations, traditionally there are 3 reasons. And with traditionally, I mean historically developed over centuries of debate. Yeah, so it's not like plucked from 1 decade of research, no, centuries long. And also legislators today still refer to those reasons. First of all, it is stated when a very long period lapses between the moment the crime is committed and the prosecution of the person, well, society forgets. After 20 years, we forget facts. We do not deem it important enough to punish someone anymore. So the need for punishment diminishes in such a way that we just say, okay, just let it be. Now, the second reason is the impact on evidence. So when a long period of time lapses, for example, 10 years, this has on a lot of different aspects of evidence an impact. For example, evidence may be lost, may be gone, may be destroyed, but also if the evidence is still there, how does it need to be interpreted? Is it still accurate? Has it become vague? Are there kind of loopholes or gaps in the evidence and so on? So the legislator says after 10 years, for example, we do not want any problems anymore with evidence. We just state, okay, after 10 years, the problems are so big, we're just going to solve it and say it ain't possible anymore. So a time limit. And then the third reason is stated that when someone has, for example, 10 years after he committed the crime, he lives in a kind of period of uncertainty. Yeah? Meaning that the uncertainty, is he going to be prosecuted or not, kind of acts as a substitute as for punishment. Now you see this is a more kind of a religious idea that is infringed into the third reason. Now you also feel intuitively that reasons 1 and 3 are more political and sociological. From when does a society feel that the need stops to punish someone or not? Therefore, they're more on the background in my presentation. I'm going to focus on the impact of evidence. And the reason being, yeah, it has to do a lot more with the legal context, which evidence is allowed, which evidence isn't allowed, and the judge ultimately always needs to decide on the evidence problem. And this also, puts into context the principles in the previous slides about avoiding false positives and the presumption of innocence. Now, to give a little bit of context, because I know I've been talking very abstractly about time limits and criminal law and principles, but what are some real life statutes or time limits that we have in Belgium for crimes? Now, one of those is kind of a very delicate topic. I've already done some presentations on, especially the time limitations with sexual abuse against minors, meaning persons under the age of 18. And when you look there, there's no time limit. Meaning if a victim of 16 years turns 65, he can still file a complaint, go to the police, and the whole trial can start. Now, when you look at sexual abuse against non-minors, so everyone with the age of 18 and above, well, the Belgian legislator decided, well, a time limit of 15 years. So that's a very stark contrast that the only difference between no time limit or 15 years is the number age. Are you 18 or not? Now, The most severe crimes in any society, when you look at the punishment, crimes against humanity, war crimes, and genocide, they also have no time limit. Now, they're a very special case. Why? Because it's an international obligation. It comes from international conventions. It's not really up to Belgium legislator to just change this. Now, another example to put some more context, the taking of hostages of mentally disabled. Excuse me if I'm not politically correct, but my English vocabulary left me in the dark about how to frame this. So excuse me, I hope everyone knows what I'm talking about. Now, when you have this crime, you have 20 years. So it's more severe, you could say, than sexual abuse against non-minors. And then murder, meaning the most severe degree, it is about killing with the intent of killing and premeditated. Yeah, so you have different degrees in how you can kill someone. I know it sounds very dark when I say it this way, but this is the most intense degree. And there the time limit is 20 years. Now, why this comparison, Driek? Well, when you look at crimes in different countries, one indication of how a society finds a crime severe is the punishment. But another aspect is there a time limit or not? And how long is the time limit? Because the longer the time limit, the more the society feels the need to punish those crimes. Therefore, the more they're deemed severe. Meaning that the Belgian legislator on the aspect of time limits finds crimes against humanity as severe as sexual abuse against minors. Again, I'm not stating my opinion if I agree or not. It's just something you can take out of this comparison. And for example, in France, this was the reason why the French legislator decided not to adopt or to abolish the time limit for sexual abuse against minors, because they stated how severe those crimes may be. They're not on the same level as crimes against humanity. And meaning crimes against humanities is on the scale of World War II, to put in perspective. And that's also the reason why we have those in our criminal code. Now, I'm a bit of chaotic person, so now a little focus to put those reasons of statute of limitations under criticism, because if I'm going to do it very abstractly, you have evidence and I do not give any example, everyone is like, okay, Driek, where are you with your presentation? So I'm just going to use this example, but know that this is also possible to extend to other crimes that you can imagine. So when you look at the abolishment of time limits against sexual crimes against minors, you see that in 2019 it was abolished, but it had kind of a legislative history. In 2016, the Belgian legislator decided to extend it from 10 to 15 years. And in 2017, they said abolishment is undesirable. And the context of that statement was in the church sexual abuse cases. Now, why did the Belgian legislator state this? Well, because they focused on alternatives. They created a kind of center of arbitration where the victim could be recognized or acknowledged for his suffering and sorrow in a more reconciliation setting with more kind of the focus on the psychological aspect, not so much on the crime and the punishment. But all that was thrown overboard completely in 2 years later. Now, I analyzed the legislative text. They're very short. It's like 10, 15 pages. And for a subject like this, that's nothing. And also, they don't really explicit why they suddenly changed in their course. Now, if you compare this with other countries, I already mentioned France. In France, there were a lot of proposals to abolish time limitations or statute of limitations. But in the end, it was decided not to abolish them. One of the reasons I already gave, because of the comparison with war crimes. Now, what did France do? They systematically extended the time limit. So in 2004, they brought it from, I think, 10 to 20 years, and then a decade later from 20 to 30 years. So now in France, the time limitation is 30 years from the moment the victim turns 18. So not from the moment of the sexual abuse, but the moment he or she turns 18. Now, the Netherlands, on the other hand, was much quicker. And they abolished those time limitations for sexual abuse against minors in 2012. And here it becomes more interesting because they gave a very extensive reasoning, and the reasoning was normally based on the emphasis of newer technologies, meaning DNA, video and audio, which in their turn would limit the problems with evidence. Now, about the problems of evidence, you think, okay, the next slide is going to be about that. No, I'm going to leave you hanging about that point. First, some other non-legal criticisms that I found in the legal documents themselves. So when I looked at the Belgium legislator, there were political parties who uttered some concerns about the abolishments. And those concerns were, in a way, legal, but most of the time not. But they were very interesting. So first, there is a principle in criminal law, or in criminal law, there's a tendency to make a balance. You have the rights of the victim and the rights of the perpetrator, meaning that a perpetrator could be an innocent person. And for those who are not really up, in the sphere, for example, in the United States, but also in the Netherlands, there have recently been an upsurge in cases where after 20 years, cases were reopened, and a lot of innocent people who have spent years in jail were spoken free because of problems of evidence and too quickly of convictions. Yeah. So therefore, criminal law needs to make a balance, and you just can't put every focus on the victim. Well, when you abolish time limitations, you do that. You put all the emphasis on the victim's perspective, which then in turns makes kind of the pendulum swing more towards the victim. Yeah. That was also uttered in the legislative text. And further on that point, the question was asked, well, does the abolishment actually help victims? And then you could ask the question, yeah, why? Well, a time limitation acts like a bar, and it does not give false hope to a victim. The police or the public prosecutor can say to the victim, well, look, very sorry, but like the case is 15 years old, we can't prosecute anymore. There's a time limit. If the time limit isn't there, well, you can file a complaint, and the police and the public ministry, they can just dismiss it without given any reason, and you as a victim are left in the dark. Yeah, what has been done with my complaint? Why is there no treatment? Are there problems? So you have a kind of information asymmetry where the victim is not held up to date with the whole process. Now, in the Netherlands, they had alternatives, and they put kind of a duty on the police and the public prosecutor to give information to the victim. So they tried to build in some mechanisms to keep the victim up to date, and to kind of give guidance in a psychological way through the whole process. But still there, it's not a very satisfactory solution, because as a victim, you just want, your needs fulfilled. But when a claim can go to court, but you're unsure, you're left with that uncertainty, even with a lot of information. So first was then the question, are they actually helped with the abolishment of statute of limitations or not? And in that case was also, even if you go to trial, so the public prosecutor says, I see something in this case, okay, a trial for a victim is not a pleasant experience. There is no psychological guidance. There's no counseling, where the political parties who criticize this stated instead of just like symbolically abolish statute of limitations, focus more on psychological guidance. Why in Belgium, for example, I mentioned the introduction of a center of arbitration where there is more conciliation and so on. Why not focus more on those projects? But the legislator, who was a majority, just ignored all those reasons and just state, we're going to abolish it. And with a beautiful sentence, they explicitly state, well, it's symbolical. So they recognize that in practice, we're not going to see any difference, but we're just going to abolish it. Why not? Now, when you then look at the more legal problems, the problems with proof and evidence, and I'm also going to touch a little bit about legal psychology, but I'm not a psychologist, so the information I give about legal psychology will be bare bones. There is a lot of very interesting literature. If you have an evening to spare, it's really interesting. And I would definitely recommend that you read something about it. Now, I mentioned proof, that you have the problem of the lapse of time. I'm going to take 20 years, for example, has an impact on proof. And you could say, Driek, well, it's all nice and all, but that's like 50 years ago. We have video, we have audio, that doesn't deteriorate. An image now stays the same. That's true, but what's the problem? Well, then in a lot of crimes, for example, sexual abuse crimes, but also violence against spouses, that's in a very private setting, and also often in a very close relationship or in an authoritative relationship. For example, the problem with the sexual abuse in the church was that, yeah, there was also a very authoritative figure. So in those cases, there was no video and audio at, yeah, disposal. So even if you have it, the chances in most of the crimes is very low. And for example, a theft in a shopping mall, yeah, it's very clear. You have a lot of cameras and so on. But in most very severe cases, also murder, that evidence of based on new technology is not there. Then you have the argument of Driek. Well, we have DNA. It's a wonderful invention. A lot of crimes have been solved. Cold cases have been solved because of DNA. And yes, that's true. DNA, in the most part, is the most strong argument against time limits. But again, a lot of crimes in a private setting, for example, sexual abuse cases, there is no DNA because DNA needs to be taken very quickly. Now, why did the legislator abolish time limits in those cases? Well, because victims only recognize their sorrow when they talk to psychologists years after the crime committed. Yeah. So then there is no DNA in most cases. Yeah. So the whole problem of DNA, in some cases it works, but in most crimes, still there is no DNA. Okay, but what if there is DNA, Driek? Well, in Belgium, but in most countries, DNA is not enough to convict someone. A judge needs supplementary evidence to find someone guilty. This cannot be based solely on DNA. So you have other necessary elements of proof. And most of the time, those are statements from the victim, statements from the perpetrator, statements from witnesses. The problem with statements is that they are based on memory, and the lapse of time still has an impact of memory. We cannot look with technology inside someone's head. We cannot take out memories. So that's still a problem. About that, I'm going to on the next slide, but now quickly again, you also have the problem of counter evidence. You as a victim may have kept some evidence throughout your career and your problems, but the accused not. So he suddenly is faced with a case of 20 years ago. He has to gather evidence. Where does he need to get any counter evidence? You also have the problem of word against word situations. Yeah? After 20 years, oftentimes, even if there is some evidence, you still have the word of the victim against the word of the perpetrator. And it's very difficult to render a judgment. And time limitations takes away that whole problem and that balancing of interests. And yeah, finally, when you look at time limitations, they're a legislative instrument, meaning that a democracy or a society has chosen that we will do away with the problem after 20 years. Whereas when you go to court, it's just one judge who is going to decide based on statements of persons if their person is found guilty or not. Now, again, I'm not saying which is the better option. Now, about the memories, very quickly, because I'm not an expert at all in this domain, is that the lapse of time, first of all, it's proven scientifically it has an importance on your accuracy of a memory. After 20 years, the accuracy of memories is very low. Yeah. A second problem are so-called pseudo memories, also called false memories. And the most well-known false memories are suggestive memories, meaning if you live through a very traumatic experience and you decide to not talk about it for years, but after 5 years, you do not go to a psychologist or something, you just talk to your friends or your family, From the moment you talk to someone, there is suggestion. Yeah, if you want it or not, has also been proven. Implicit, there is going to be suggestion in your memories, meaning you can't really know if your memory is accurate and not based on false information. And the problem of pseudo memories is really a very prominent one, because there are been a lot of people found guilty that were innocent based on false memories that are later, like 10 years or decades later, with other evidence being reviewed. Then you also have the problem of incomplete memories. Yeah. Most of the time, when you want to remember something, you know certain parts but not the details, and then you try to fill it in yourself, which is also very problematic. And finally, you have myths about repressed memories. This has been a scientific discussion for, I think, over 30 or 40 years now in legal and psychological research. Repressed memories date back to Freud, who said when you have a traumatic event, it can be that your memory just like does a kind of, sorry for my terminology, dissociative amnesia or something, meaning that it's just like blocked out. And then suddenly 30 years, you're sparked by something and it comes back crystal clear. Well, that's not the case. That doesn't happen. But that myth somewhere in this world still lives. For example, in France, the French legislator based their extension of the limitation period purely on repressed memories, which is scientifically very discussed and on the basis of the recent scientific research is being reviewed. You could say, Driek, that's very simple. It's just a choice between you have evidence evaluation by the judge or time periods in legislative form. And that's true. I'm just giving different options now. You can put your arguments in either camp. Now, like I already mentioned, evidence evaluation by the judge is not easy. Why not? The judge, most of the time, they're very competent, they have a very broad knowledge, but they're not psychologists. They're not psychological researchers. They do not know the state of the art of repressed memories or false memories. They just have to do it by a hunch. Uh, there's nothing inherently wrong with it, but it's not. When you look at the cornerstone of avoiding false positives, it gets kind of wishy-washy and problematic. Whereas time limitations, the legislative in a democratic society decides, okay, we as a society do not find it acceptable anymore. Are there other alternatives? Well, there are on two levels. You have pre-trial alternatives, meaning before there is any criminal trial before a judge, and you have alternatives in trial for statute of limitations. First, pre-trial, I'm going to be very quick because I see I only have 2 minutes left. You have the more important role of the public ministry and the police. Like I already mentioned, in the Netherlands, they took that approach. They gave more guidance. They also um, educated the police about memory. So there the police has a basic understanding of the scientific background. If someone files a complaint, for example, about sexual abuse, what are some pitfalls? How can you recognize where this is going? And also how they can inform the victim of how a trial works, what are going to be possible next steps. Is there something in the case or not, and so on. What is also the possibility is the creation of a committee. Where did they do this? Again, in the Netherlands. There you have a committee of judges and legal researchers and professors who have an advisory role. So they inform the public ministry, police, and judges about certain memories. Yeah. So when there is kind of a doubt, they can ask a question and they will make a report that states that we think there is some viable evidence, or now this memory is too false. For example, memories before, I think, 2 or 3 year olds. No, let me paraphrase it other. Children between 0 and 3 years, they do not really have memories. That's also scientifically proven. So when someone files a complaint that they were abused when they're 1 year old, that's, yeah, you can't remember that. So that's kind of an example. In trial, you could say, okay, if we have no limitation periods, we just focus more on the role of the judge, but also other legal figures. I wanted to go into that, but that's going to be take too long and too technical. You have from the European Court of Human Rights, so it's also an international level. You have the reasonable period, meaning that from the moment someone is being prosecuted, he has to been trialed within a reasonable period of time. Now, you hear it in the word reasonable period of time, meaning that they also take into account when time is elapsed, the problems on evidence, and the longer um, time between the prosecution and the trial, the higher the chance there's just an inadmissibility like statute of limitations. And also there is also some very interesting legal scholarship about how statute of limitations can be reformed and give other forms so that they can still exist but in a more modern sense. Then I had some concluding remarks, but that's I'm going to skip those for okay. I see nodding. I will very quickly then go into. So one of the problems, in my opinion, with the limitation periods is the too much focus on the victim and lacking the wider context of criminal law. Is this a problem? No, but then legislators need to revise their whole criminal law foundations instead of saying this is our foundation of criminal law, but the rules that apply those foundations, yeah, they go out from another foundation. Yeah, that's not wrong. So like change one or the other, do not change one or the other, change both or none of the two. Also, law is not the best place suited to recognize victims. For example, after 30 years, if you want to recognize or acknowledge victims, you have other matters and that are much better placed than the punishment of a perpetrator. And if the sole focus for the abolishment of limitation periods is the focus on the victim, yeah, there are much better alternatives than law to, of course, yeah, make that come true. Also, the problem with legislative reform and the abolishment is the lack of implementation of psychological research. And of course, a lot of those changes are symbolic. And my question is, why do you change legislation if it's just symbolic? Legislation needs to have a purpose and a goal. Otherwise, it's just there for show. Yeah, I do not really see any value in that. So now I spoiled you with my own vision and opinion, which I did not want to do. So I hopefully, have some people who disagree with me.